We're live.
All right, we're back live. Katie, sorry for the disruption there. And before you get started again, though, Senator Bohovsky has a question for you.
Thank you. My question, and it just not being as familiar with the various different processes, in this process, what legal representative rights does a person have who is going through the process?
The statistic I've heard is that I want to say over 90% of the cases, Vermont Legal Aid is representing somebody going through this process. My guess is you will be hearing from Jack McCullough at some point on this bill, and he will correct my statistic if I have gotten it wrong. But I think a vast majority of the cases is going through this process are through Vermont Legal Aid, and alternatively, somebody could have a private attorney.
They have the right to an attorney through this process. Okay, thank you.
Mm-hmm. Okay, so I'm picking up on section 4. As I said previously, we've gotten through the application for involuntary treatment, the hearing, and at this point, the court is making an order. And in this particular section, the order is specific to an order of non-hospitalization. And there is the addition of a second paragraph in subsection A, that if the commissioner determines that treatment at a forensic facility is appropriate, the court shall order the person to receive treatment there for a period of 90 days. The court may at any time on its own motion or on a motion of an interested party review the need for treatment at the forensic facility. Then we have some conforming language changes at the bottom of that page, and we move on to section 5. So I guess I should take a step back. Section 4 only deals with the initial order for an order of non-hospitalization. After somebody gets past that potentially period of up to 90 days on that initial order, the state can seek an additional course of treatment under an order of non-hospitalization, and that would be called an application. The state would have to file an application for continued treatment. So that's an application for a continued treatment. I see there's a hand. Should I?
Yeah, I just had a clarifying question. So you just said it was not more than 90 days, but my understanding of the bill language is that it's for 90 days. It's not an up to 90 days. It's just for 90 days. Is that correct?
Let me look at the words again. Receive treatment there for a period of 90 days. Yep.
So that like is, and again, I'm learning all the legal aspects. So that is just, it's not an up to or not more than 90 days. It is very explicitly for 90 days.
It says 90 days and that's the reading of the language, but
Okay.
You'll see in the second sentence that there's a sentence that the court at any time on its own motion or motion of an interested party can review the need.
Okay.
So potentially that gives the option for review before that 90-day period has been completed.
Okay, thank you. Sorry.
No, these are good questions. Okay, so after the period of 90 days, that initial order of non-hospitalization has been completed or is coming close to completion. If there's a belief that that individual still needs continued treatment, the department would file an application for continued treatment. So that's what you're seeing in section 5 is that continuation of treatment. Interestingly, this statute has been amended in the past to kind of account for a very similar situation. So the state has the Secure Residential Recovery Facility, which is in Middlesex. And a number of years ago, when the Secure Residential Recovery Facility was developed, this subsection D on line 13 of page 8 was added to sort of do the same thing that we've already seen with regard to the application for involuntary treatment. It specifies what has to be in the application. It specifies that if treatment is sought at the Secure Residential Recovery Facility, that is specified and the reasons for doing that are specified. So our amendment to that subsection in this bill is very narrow because we're just kind of building on the language that's already been put in place by adding forensic facility where in a list where Secure Residential Recovery Facility is already added. So you'll sort of note in distinguishing the forensic facility and the secure residential recovery facility. This is the first time that we're seeing anything about the secure residential recovery facility, meaning that you can get a continuation order to the secure residential recovery facility, which is different from the forensic facility that's being proposed. So in other words, somebody who's going into the secure residential recovery facility is first under an order of hospitalization, and then for their continued treatment, they're moving to the secure residential recovery facility. Whereas under this proposal, an individual could have their initial order of non-hospitalization in the forensic facility. They do not need to go through a hospital first. Is that clear, that distinction? Or clear as mud?
Clear as mud.
Okay. So basically, let me try again. Basically, a person who's going into the forensic facility does not necessarily need to have to go to a hospital first. They could potentially, but they don't have to. Under the secure residential recovery facility, the way this is set up, they can only receive continued treatment there, meaning that they have first had an order of hospitalization before moving to the secure residential recovery facility.
Got it. Thanks.
Okay. And let me just go through this subsection now that we've chatted about it. If the commissioner seeks to have the patient receive the further treatment in a forensic facility or secure residential recovery facility, the application for an order authorizing continued treatment shall expressly state that such treatment is being sought. The applicant shall contain, in addition to the statements required by subsection B of this section, a statement setting forth the reasons for the commissioner's determination that clinically appropriate treatment for the patient's condition can be provided safely only in a secure residential recovery facility or forensic facility as appropriate. So we're just piggybacking on that language that's already there with regard to what is part of the application for continued treatment. The next section on page 9 pertains to the hearing on the application for continued treatment. And again, we're sort of piggybacking on the secure residential recovery language that is already in statute. And this language says that if the application for continued treatment seeks further treatment in a forensic facility, the court may at any time review the need for treatment at the forensic facility on its own motion or the motion of an interested party. So we're building off existing language there. Next, page 10, section 7. We're moving on from treatment, and in that case, again, treatment meant commitment, to involuntary medication. So this is a different type of application, and this is potentially an additional court process. So you'll see in subsection A, there is a list. This lists the current 6 conditions under which the Commissioner of Mental Health may commence an application for involuntary medication for persons refusing psychiatric medication, who the Commissioner believes needs those medication. So what this bill does is it adds a 7th condition. Confusingly, the 7th condition on page 11 will be item number 6 on the list. So this new condition to apply for an application for involuntary medication is that the individual has been placed under an order of non-hospitalization at a forensic facility. So that alone, being in the forensic facility, means that the commissioner could apply for involuntary medication, or the individual has an application for involuntary treatment at a forensic facility pending, for which the court has granted a motion to expedite, and regardless of whether the person has previously been under an order of hospitalization or not. So either the person is already in a forensic facility, in which case this application for involuntary medication is appropriate, or secondly, the person has this application for involuntary treatment at the forensic facility pending, and the court has already agreed to expedite the hearing on that application for involuntary treatment. So those are the 2 conditions under which the application for involuntary medication could be made. Let's see, on line 14, we're using gender neutral language. On page 12, we have language in subdivision 2 on line 3 that if the application for involuntary medication is filed pursuant to subdivision A4 or A6, A6 is our new subsection that we're contemplating adding, that the applicant shall be filed in the county in which the application for involuntary treatment is pending, and the court shall consolidate the application for involuntary treatment with the application for involuntary medication and rule on the application for involuntary treatment before ruling on the application for involuntary medication. So basically, if an application for involuntary medication is coming in on the grounds that there is a pending application for involuntary treatment, the court can decide to consolidate, or it can't decide, there's no discretion there. It has to consolidate those two applications and rule on them at the same time, although you'll see there's sort of a hierarchy. So first we're going to rule on involuntary treatment and then the decision on involuntary medication, but those two applications are treated together, they're consolidated. Subdivisions 3 and 4, these are just conforming changes because I've sort of renumbered in that list we looked at. I've renumbered here just to be consistent. So we're still having the correct cross-reference. And that is it for that section. That brings us to page 13, section 8. This is the finding and court order with regard to involuntary medication. So for a person who is receiving treatment pursuant to an order of non-hospitalization in a forensic facility, if the court finds that without an order for involuntary medication, there is a substantial probability that the person would continue to refuse medication and as a result would pose a danger of harm to self or others, the court may, I have to strike the word that. The court may order administration of involuntary medications at a forensic facility for up to 90 days, unless the court finds that an order is necessary for a longer period of time. An order for involuntary medication pursuant to this subsection shall not be longer than the duration of the current order of non-hospitalization. If at any time the treating psychiatrist finds that the person subject to an order of involuntary medication has become competent, the order is no longer in effect. Okay, so when we turn to page 14, we're moving out of the part of the bill specific to individuals with mental illness, and we're moving on to the commitment of individuals with an intellectual disability. So we're sort of changing the population that we're looking at. And as we noted on that second page, when I said there are two different standards, the processes are a little bit different. In the intellectual disability context, the language is a little bit more straightforward, and there are less steps in the process. So hopefully this will be a little bit more straightforward. So in section 9, you'll see we're amending Title 13. So we're looking, this is from a criminal title. We're not looking in the civil title yet. So here, the proposal is to delete the existing subsection B and instead include language that judicial review procedures for an order issued pursuant to subsection A, meaning that a person is in need of custody care and habilitation, and for discharge from an order of commitment shall occur in accordance with the civil commitment process that we'll look at next. So this 8845 sets out the process for commitment and discharge. We'll continue to talk about this as we sort of move through this part of the bill, but you'll see that Dale is proposing to remove a number of sections that are not, they call them form without substance, and I'll sort of explain when we get there. But this subsection B references those sections that Dale is proposing to remove. So I believe that the change in subsection B, these repeals are because 8843 would likewise be repealed. Okay, and then in subdivision C1, we have that. We similarly have a removal or repeal of language, and the replacement is that if the commissioner seeks to have a person committed pursuant to this section placed in a forensic facility, the commissioner shall provide a statement setting forth the reasons for the commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility. And then we're using the same definition of forensic facility that we went over on the first page of the bill. Okay, then in section 10, we're moving from the criminal process that to the Title 18. So we're moving to the civil process. The definition of danger of harm to others is being removed, and instead the definition of commissioner is being added. On page 16, the definition of a person in need of care and custody and habilitation is being amended to mean a person with an intellectual disability, which means significantly sub-average intellectual functioning, existing concurrently with deficits and adaptive behavior that were manifest before 18 years of age, and who has inflicted or attempted to inflict serious bodily injury to another, or who has committed an act that would constitute a sexual assault or lewd and lascivious conduct with a child, and for whom appropriate custody, care, and habilitation can be provided by the commissioner in a designated program. Then the definition of a person in need of continued care, custody, and habilitation is added. And this addition sort of makes the process for individuals with intellectual disabilities a little bit more parallel to the mental health statutes, in that there is the initial order and then there's a continued order. So this definition means that a person who is previously found to be a person in need of custody, care, and habilitation, and who still poses a danger of harm to others, and for whom the commissioner has, in the commissioner's discretion, consented to or approved the continuation of the designated program. And then it goes on to say that a danger of harm to others shall be shown by establishing that in the time since the last order of commitment was issued, the person has inflicted or attempted to inflict physical or sexual harm to another, by the person's threats or actions has placed another person in reasonable fear of physical or sexual harm, or has exhibited behavior demonstrating that absent treatment or programming provided by the commissioner, there is a reasonable likelihood that the person would inflict or attempt to inflict physical or sexual harm to another. So that's our definition section. Then we get on page, we get to page 17, and you'll see section 11, 12, 13, and 14 are all being repealed. So let me just step back and explain this as best I can. So we are amending chapter 206 of Title 18 here, which pertains to individuals with developmental disabilities. And 1995, subchapters 1 and 2 were repealed. Subchapter 3 was retained at that time, and it provides a mechanism for an interested person to petition the court for state supervision of a person with intellectual disabilities who presents a danger to self or others. However, subchapter 3 cross-references provisions in subchapters 1 and 2. And in essence, it's what Dale calls form without substance, that subchapter 3 cannot provide an avenue for commitment without having subchapters 1 and 2. So in deleting the sections 11 through 14 from subchapter 3, that the idea is that they were not able to be used anyway because subchapters 1 and 2 had been repealed in 1995. There's probably more detail if you want to dig in there, and I would refer you to Dale with specific questions on that particular proposal. Okay, this brings us to page 18, legal competence. The amendment here is that no determination that a person is in need of custody care and habilitation or in need of continued custody care and habilitation, and no order authorizing commitment shall lead to a presumption of legal competence. So we're just adding that kind of next step of continued custody care and habilitation that was created by the previous section of this bill. In section 16, a person who is committed under 13 VSA 4823, again, this is individuals with an intellectual disability who are coming in through the criminal door, or who are coming in through this subchapter, meaning the civil door, may be discharged from custody by a superior judge after judicial review was provided in accordance with this subchapter or by an administrative order of the commissioner. At least 10 days prior to the effective date of any administrative order for discharge by the commissioner shall give notice of the discharge to the committing court and to the state's attorney of the county where the prosecution occurred. Subsection B is the existing language is being repealed. Again, that reference on line 4 to 8834, this is a section of statute that was previously repealed in 1995. And instead, there would be a newly renumbered subsection B that would read that a person committed either through the civil or criminal door shall be entitled to a judicial review of the person's need for commitment annually. The family division of the Superior Court shall have exclusive jurisdiction over all judicial review proceedings brought under this section. If no judicial review is requested by the person within 1 year from the date of the last order of commitment, it shall be initiated by the commissioner. However, such person may initiate a judicial review under this subsection after 90 days of the initial commitment, but before the end of the first year of commitment. Or if the commitment has been continued under this subchapter, the person may petition for review after 90 days from the date of an order for a continued commitment. In subsection C, if the commissioner seeks to place the person committed pursuant to this subchapter in a forensic facility, the petition shall expressly state that this placement is being sought, and the petition shall set forth the reasons for the commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility. So that language is very similar to sort of the requirement in the mental health part that the specificity of where the individual will be committed to the forensic facility and why has to be in that as part of that process, part of that application. In subsection D, the Vermont Rules of Evidence of Procedure applicable in civil cases shall apply to all judicial review proceedings brought under this subchapter. The commissioner or the commissioner's designee shall attend the commitment hearing and be available to testify. All persons to whom notice is given may attend the commitment hearing and testify, except that the court may exclude those persons not necessary for the conduct of the hearing. And then we have language in subsection F that at the completion of the hearing and consideration of the record, if the court finds by clear and convincing evidence that at the time of the hearing that the person is still in need of continued custody care and habilitation, commitment shall continue for an indefinite or limited period. If the court finds at the time of the hearing that the person is no longer in need of continued custody care and habilitation, it shall discharge the person from the custody of the commissioner.
Hey, can I just ask you a real quick question for line 10? Was clear and convincing evidence, was that the standard that was being used before clarifying language?
You know, I'm not sure the answer to that question, if it is what the current standard is. So I can look into it, or I'm sure you'll be hearing witnesses from Dale who could answer that question.
Thank you.
Okay, so that brings us to section 17, which is the certificate of need. The certificate of need is a process by which new medical facilities have to, there has to be a determination of need by this in the state before they are approved. And so there is an exclusion added into this section. Excluded from this subchapter is any forensic facility supervised and operated by the Commissioner of Mental Health or the Commissioner of Dale or both. So this is basically saying the forensic facility wouldn't need a certificate of need. And then we have two rulemaking sections. Section 18 has to do with the admissions criteria for the forensic facility. So by July 1st of this year, the Secretary of Human Services, in consultation with DMH and Dale, are required to, or would be required to, file an initial proposed rule with the Secretary of State specifying the criteria that the department shall use to determine admission to a forensic facility and the process used by the commissioners to determine the appropriate admissions. So what this is saying, this is saying that the rulemaking process is initiated by July 1, 2023. And this section and the next section take effect on passage. So in theory, this, depending on the, if this bill is taken up and how it moves, this bill could be enacted earlier than July 1, 2023. But the idea is that that initial filing happens and that the process of adopting admissions criteria for the forensic facility is in process by July 1, 2023. The LCAR process, it's not just LCAR, the rulemaking process under the APA can take a bit of time. I think the fastest it could take, I don't want to speak out of turn, maybe 7 to 9 months would be kind of a fast process for a rule to move. So by setting a date that the initial rules are filed is sort of asking the agency to get this process started earlier rather than later, acknowledging that it takes a substantial amount of time for rules to go through the process. And then in subsection B, it's stating that the departments cannot admit residents to the forensic facility until a permanent rule has been adopted, meaning until the rulemaking process in which a permanent rule is adopted for admissions criteria and the process that the commissioners use to determine who is appropriate for admission to the forensic facility until that piece is in place. And then in section 19, this is another rulemaking requirement, and this has to do with kind of conforming amendments of existing rules pertaining to involuntary medication. So again, by July 1, it's asking the commissioners respectively, because they have two different rules that are listed below, they shall file initial proposed rule amendments to account for the establishment of the forensic facility. Specifically at the top of page 22, Dale has an existing rule on the licensing and operating regulations for therapeutic community residences. And so the request or the requirement is that that rule be amended to allow for the use of emergency involuntary procedures and the administration of involuntary medication at the forensic facility. Currently, therapeutic community residences don't allow for EIPs, emergency involuntary procedures, or involuntary medication. So this would be an exception to add to the rule. And then the second piece, the second paragraph, the Department of Mental Health currently has rules for the administration of non-emergency involuntary medications, non-emergency involuntary psychiatric medications, and these would be amended for the purpose of allowing the administration of involuntary medication at a forensic facility. So conforming amendments to match the statutory changes that would occur in this bill. And then in terms of effective dates, we've sort of already touched on this, but the effective date section and the rulemaking sections would take effect on passage to give a little bit more time for the initial rulemaking filings to be put in place. And then the remaining sections wouldn't take effect until July 1, 2024. So that would give a whole year on passage before the forensic facility could potentially be up and running and governed by these statutes.
Thank you, Katie. So I have one question that might actually be a question for the sponsors of the bill. And I feel like something has either gone over my head or I've missed it, but where is this forensic facility that we're
Yeah.
talking about? Are we building a new one or planning to build a new one? Because I feel like a lot of places are at capacity or close to being at capacity right now. So am I missing something or?
You are not missing anything, and I'm going to let the witnesses that follow me answer that question.
Oh.
So what this bill does is it does not construct a new facility. It puts sort of the operating process in place for how a person could end up in that facility. But I will let the next folks testify, speak to what is being considered for a potential forensic facility.
Great, thank you.
Thank you, Senator Shame. I too was wondering
Yeah.
what we were talking about here, because to my knowledge, this facility does not exist.
Yeah.
It does not, you're correct.
Gotcha. Well, thank you very much, Katie. Do either of you have any questions for him? Okay. So we have Emily Hawes next.
That's me. Hi. Morning. For the record, Emily Hawes, Commissioner for the Department of Mental Health. Thank you for having me. Would you like for me to start with your question? Because
Yeah.
okay. So I think that will help frame out the talking points here forward. So what we are thinking of for consideration currently is utilizing 9 beds currently at the Vermont Psychiatric Care Hospital. The Vermont Psychiatric Care Hospital is a 25-bed inpatient facility located here in Berlin. And folks who are currently receiving hospital level of care there are committed under the care and custody of the Commissioner of the Department of Mental Health. So what we're looking at here with those 9 beds, which is a separate section of the hospital is set up into 2 wings, 2 units on each wing, 16 beds on one side, 9 beds on the other side. So we're looking at the 9 beds, so a small number of beds, and a different level of care, a step down from a hospital level of care. And the reason we're thinking about that is for our purposes, when we think about those individuals who are interacting with the criminal justice system and the court system and our hospital system, we find that folks who need to be placed in a hospital in order to receive their care get access to hospital beds. Folks who don't meet hospital level of care may still have a considerable amount of violence or risk for violence and need considerable treatment, but might not meet the threshold of needing, say, 24-hour nursing care in order to meet their treatment needs. So what we're proposing here is to create a new level of care. And like I said, we have a hospital system that currently admits folks who need to be in the hospital. And this would see folks who have a lot of clinical needs, but don't meet that admission criteria into a hospital setting. Let's see. We currently have the MTCR or River Valley Therapeutic Community Residence. That's currently located in Middlesex and soon to be moved to Essex as a 16-bed facility. That facility is a secure facility. However, they do not administer any involuntary emergency procedures or have an opportunity to deliver medication to somebody on an involuntary basis if they need it. An individual would need to be screened and then go back to the hospital should they need that level of care. So that's why the talking point around emergency involuntary procedures and involuntary meds is really important when we think about the forensic facility, because individuals are still presenting with a higher risk of violence and treatment needs. And so in order to best serve them, we need all the tools in our toolbox to do that. And that is one section of the toolbox we would like to have for consideration.
Just got a quick question.
Sure.
I don't know, you're talking about a 25 beds available, but you're only going to use 9 of those beds.
The other
How many of those
16 will
beds
stay
in-
hospital.
they're gonna stay hospital, how many of those beds are gonna fill the ASAP here, those 9 beds?
Well, that's why we're talking about why the admission criteria is really important here. And that the commissioners of both Dale and DMH and the court are working together to determine who makes the most sense to go into a limited number of beds.
Senator Middleskin.
Yeah, I have two. One is kind of directly related to Senator Norris's question. So these are not 9 new beds. They're 9 beds that we're taking offline from
Right.
one system and putting online in another system. What impact is that going to have to the people who are sitting in our EDs needing hospital level care for weeks and months on end?
Sure. Well, not many of the folks waiting in EDs are folks who are involuntary or need the highest acuity setting to receive their treatment. Most folks who come through an emergency department, about 90% are voluntary and don't require long-term stays. So the folks who go to the Vermont Psychiatric Care Hospital for treatment are typically folks who have either been ordered there for a competency or sanity evaluation, are folks who require additional resources in order to safely meet their treatment needs. Additional resources can mean additional staffing, additional access to psychiatry. There is an opportunity, if needed, to go through the involuntary medication process there. And so it would take 9 beds offline for folks who need high acuity. But we're also seeing that there's a difference in folks presenting for inpatient care, and we don't necessarily need an inpatient care to serve those individuals. And so it could be that some folks who may get referred to, say, a level 1 bed may be more adequately served at a forensic facility.
Okay, I guess my concern, because I just keep hearing across the board that we just don't have enough beds, is what impact does it take?
Sure.
Is it gonna have on that system, sort of shifting these? Presumably those 9 beds are occupied by someone right now. Where will those, okay, so where will those 4.5 people go?
Well, hopefully they would get treatment and discharge. And I think when we talk about how many beds or do we have, is that enough or not enough, really oversimplifies the whole system.
Of course.
So if our community system isn't well funded and well resourced, then of course things get pushed up to the highest levels of care.
Of course.
We have other initiatives happening right now to meet the needs, hopefully, for folks in a more prevention, early intercepting folks who are experiencing mental health and substance abuse challenges. Our hope is that some of those initiatives can get to folks before they need the higher level of care. And so there will be likely an impact initially. However, I think for the most part, folks won't see that, and another population will get access to care that they're not currently getting.
Okay. That's helpful. My other question, I've got a really good sense of what involuntary medication is in the psychiatric facility setting, but what is an involuntary procedure?
Yeah, that's a great question, because oftentimes people associate involuntary as just medication. So an involuntary procedure can be as limited as limiting somebody's movement forward. So preventing someone from, a staff member maybe needing to prevent somebody from leaving the room. Hands-on. It also could mean somebody who might require a seclusion, which would be in a safe seclusion space. It also might mean somebody would need restraint, and that can happen in a restrained bed, a chair, so to speak. So there are numerous interventions that qualify as an involuntary procedure. And I'd like to highlight as a whole, Vermont has a very low in general EIP and involuntary med rate. When you compare us nationally, involuntary emergency and voluntary procedure. Yeah, we have a low rate per 1,000 hours when compared nationally. Vermont Psychiatric Care Hospital has the lowest in Vermont. And so we really only use those interventions when it's clinically indicated. And like I said earlier, the more tools in the toolbox to support someone through their treatment, the better.
So an involuntary procedure would not be like involuntary ECT or involuntary, okay, thank you.
Mhm. Okay. I wanted to talk a little bit about due process, because I think that you mentioned earlier what was the legal representation of individuals who may be coming in and out of this facility. So every person admitted is represented by an attorney, and likely would have two attorneys, a public defender from the initial charge, and then likely a legal aid attorney as they move through the court process. And while we're asking that only DMH or Dale can seek to put someone in the facility, the ultimate decision rests with a judge and a court. And so the judge and a court can say no. If the individual doesn't meet the statutory requirements and or is not the least restrictive level of care. In addition to the court and the judge, the person's attorney can also petition the court to reconsider the order and argue that the forensic facility is not the least restrictive.
Just a quick question. So this in its entirety, in spite of, even though it is, we're talking about forensic cases, is subject to the Olmstead decision?
That's a good question that I'm not sure the answer to. So perhaps one of Stuart or Bart might know the answer to that. Okay, no, that's fine. And I subbed in Karen Barber is our general counsel, and she was unable to be scheduled today because she was on a flight. So.
Bart wants to comment on that.
Yes, this would be subject to Olmstead and the ADA requirement that this is the least restrictive environment. And that is why the court would be approving any application for placement within the forensic facility.
Thank you.
Okay. Again, I talked a little bit about emergency and voluntary procedures. Those would only be performed under our current EIP rule, emergency and voluntary procedure rule. The state of Vermont has a rule, so does the Center for Medicaid and also Joint Commission. Those are the two entities that oversee our hospital setting. The Vermont rule is even more restrictive of what is considered an emergency and voluntary procedure. So our idea would be that this would follow those same rules that are in existence. Disability Rights Vermont gets a copy of the documentation for every emergency and voluntary procedure in the state, and we would continue to do that here. And they assess whether they agree it met the rules interpretation. Additionally, with involuntary medication, we would also only be given pursuant to a court order within the current existing process. And then like an order of non-hospitalization to the Middlesex Therapeutic Community Residence or soon to be River Valley, the decision of who is eligible for this facility rests with the custodial commissioners, with DMH and Dale, but is dependent on a court's decision that the person meets the requirements of Titles 13 and 18 or no HR Act 248 order, and that it's the least restrictive setting possible. There are a couple of concerns related that I'd like to highlight, and that's around the definition of a forensic facility. We're concerned that this language is too limiting for the DMH purposes and request the committee consider amending this section. When someone comes into DMH custody through Title 13, they don't stay in our custody pursuant to Title 13, but instead after 90 days, it moves into Title 18, which is family court. Thus, the committed pursuant language would limit it to the 90-day order. One suggestion may be to say that the person is initially committed pursuant to Title 13. So I asked the committee to consider that. Another concern would be around rulemaking and admission criteria. DMH and Dale believe that that's unnecessary and overly burdensome and would negatively impact the ability of the departments to use the facility. We don't feel we need a rule to assure due process. Due process already exists. There's clear criteria and statute as to when someone can be in DMH or Dale custody. That's through the order of non-hospitalization or Act 248 order. And the court has the ultimate authority to determine admission, and the individual has an attorney to represent them. DMH and Dale need to assure that it's the least restricted setting. So what we're actually talking about here is not necessarily about an admission criteria, but how do two departments manage a small subset of beds for this new level of care. DMH and Dale need flexibility and the ability to change and adapt as the facility opens and we learn more how it works. This is even more so if at some point in the future we add restoration to the mix. So competency restoration, which is not something that the state of Vermont is required today. DMH and Dale proposed language that instead requires the two departments to execute an MOU. Just like the legislature did with DMH and Department of Corrections back in the 2017-2018 with Act 78. We see these situations as the same. That was also a situation where two departments had clear statutory authority, but the legislature wanted to make sure there was a clear process in place to outline how the two will work together. The MOU made sense, and both DMH and DOC find this MOU as an effective tool for us working together, and so we suggest having a similar process for DMH and Dale. And then we can provide some language suggestions related to what was in Act 78.
Thank you.
Yeah, any questions? Happy to answer.
Any more questions?
I do, but it might be for legislative council, so I can wait.
So we've got 10 minutes left. Thank you for your testimony.
You're right. Yeah.
Jay, do you want to fit it in 10 minutes or do you want to come back?
Up to you. I mean, my background, it's really more background, why we think we're here, where we're proposing this facility. I don't know, I think I can do it in 10 minutes. So
Okay.
It's up to you.
Yeah, let's hear it, and then if you get cut off, we'll just tell you that.
Keep it for lunch. So hi, for the record, Jake Pershing Johnson, Governor State Council.
Sorry, Jason. That was me.
Thanks, Commissioner.
Yeah.
Yeah, you do have the experts in the room, the commissioner, the councils, Karen Barber, who is not in the room, but is the general counsel for DMH. So they are best positions to answer the process questions. I appreciate the leadership of Senator Sears, Senator Baruth, and Senator Lyons in sponsoring this bill to establish a forensic facility capable of providing both care and a secure setting for Vermont's violent, mentally ill criminals. It's a complex and controversial topic, and we look forward to supporting the committee as it takes on this difficult work. The governor framed the issues in his 2023 inaugural and budget addresses when he said, 12 years after Tropical Storm Irene, we still have not finished rebuilding our mental health system. This has led to fewer options for patients, and too often they end up in emergency departments which are not equipped to care for them, despite the nurses and doctors doing their very best to help. The governor spoke of the intersection of the mental health needs of Vermonters and our public safety challenges, saying violent, mentally ill adults need both treatment and a secure setting. But if they don't meet, as the commissioner explained, but if they don't meet specific federal criteria, they can't stay in the state psychiatric hospital. So my administration has identified beds to help address the gap without impacting the budget. So S79 is 89 will address one critical gap in our system of care, the need for a facility able to deal with criminal justice involved persons who do not require hospitalization, but require care in a secure setting. This bill, as well as S91, relating to competency to stand trial and insanity as a defense are priorities of the governor. As background, and probably everybody is aware of a lot of this background, the gap between the criminal justice system and the mental health system of care was brought into high relief for this administration in October 2018, when a defendant charged with second-degree murder and manslaughter in connection with the death of Betty Rodriguez in Springfield, Vermont, was released from the state psychiatric hospital after 10 months. In this case, rather than bring the case to trial, after the evaluation of 2 experts, the prosecution and the defense agreed this defendant was both incompetent to stand trial and insane at the time of the offense. The judge ordered hospitalization and the offender was released into the community 10 months later. DMH can't speak to individual cases, but this and my descriptions of these cases are all in the public domain. In 2019, a prosecutor dismissed 2 murder cases and 1 attempted murder case after determining she did not have enough facts to prosecute the cases and rebut the defendant's planned insanity offenses. The prosecutor was quoted as saying, "Justice for the victims is in the hands of the Department of Mental Health." 2 of these cases have been prosecuted and the 3rd is anticipated to go to trial, but these 4 cases together are an indication that these offenders are at least as likely to be referred to the mental health civil commitment process as to be prosecuted for their crimes. Prosecution is difficult, expensive, and time and staff intensive. However, the mental health system is not designed to be the last resort to ensure public safety or justice for victims. The mental health system treats mental illness. Clinical determinations of eligibility for care, dangerousness, competency are not the same as in the criminal justice system. Definitions differ at the clinical level and at the, and as they're set forth in our statutes now. One example is a question I have about the bill when it discusses involuntary medications. There's the use of the word competency. Is this legally competent to stand trial? Is the person at that point able to participate in their own defense? Or does it just mean that they no longer need involuntary medication?
Sharon, what page is that on? I just want to highlight it.
I don't have the number. I don't know if Katie has it. The other question with respect to competency is there is a specific provision in one of the later sections, I think, that refers to the Dale process, and the release to a step-down facility does not indicate legal competence. So there is a distinction between competency for certain purposes in a clinical setting, it seems to me, and in the courtroom, and the legal definition for competency. There are other determinations regarding dangerousness, where a court and a prosecutor and a defense attorney may all agree a person is too dangerous to release into the community, but DMH makes a clinical determination without hearing from victims or all of the other stuff that a judge will hear in the community. They make a clinical determination regarding dangerousness and place them in a different facility. And that typically leads to a lot of negotiations about appropriate placement. But the language just isn't the same between the clinical setting and the legal setting. As the state's attorney said at the time of the 2018 Springfield Agreement, the mental health system is not really designed for people who pose such a great danger to public safety as the defendant in that case, or any other murderer who is insane. The law really does not provide for long-term commitment. The presumption is always that we are always considering release. Most recently, it was reported, a defendant murdered 26-year-old Emily Heyman in downtown Bennington in broad daylight after lying in wait. There is other evidence that this offense may have been premeditated.
Just so you know, just giving you a heads up, about 2 or 3 minutes left.
Okay, sorry.
Just so you know.
This offender was determined to be not competent to stand trial. However, rather than dismiss the case and leave it to the civil process, all parties agreed that the criminal court would retain jurisdiction and leave the bail restrictions in place. but transfer the offender to the custody of DMH for a 90-day period of hospitalization. The goal is to maintain the defendant in a secure facility with treatment to restore competency so that he can stand trial and participate in his criminal defense. The biggest challenge facing the state right now is keeping this dangerous defendant in a sufficiently secure facility. Because if he no longer meets the hospital level standards of care, he will have to be stepped down to a different facility with a lower level of security and treatment. Others can speak to the security of the mental sex facility. So anyway, at a very operational, practical level, there is currently no adequately secure facility capable of providing both long-term care and shorter-term competency restoration to mentally ill individuals who have been charged with violent crimes and who do not meet a hospital level of standard of care. This is a source of great frustration to courts, prosecutors, defense attorneys, victims, and the families of victims, the families of offenders who do not wish to see their loved ones at further legal jeopardy, and our communities. As was mentioned, Dale and DMH have come up with an elegant and cost-effective solution by proposing to use beds in space already available in the psychiatric hospital. So, I mean, I think, and I guess, again, to the senator's concern, I mean, these aren't new. These people aren't new to the system. It's not as if, where are we going to put the other people? These people are going into our system anyway. This is just a more appropriate placement for dangerous individuals who don't need a hospital level of care. Anyway, thank you for your consideration. We are open to alternative suggestions for drafting as long as they get us to the same place. Maybe more efficient to articulate a process in Title 13 to streamline this process a little bit for offenders who are not bouncing between the criminal process, like in the Bennington case, the civil process back to the criminal process. Also, we would support the commissioners drafting suggestions. And again, I would defer to subject matter experts on process questions.
Thank you. And if you have any additional stuff you want to share, we can do the agenda later on, and then we'll also push the other folks, Emma and Shayla, to the next time that we talk about this. So, yeah.
Yeah, and just the defendant you're discussing in Bennington, if they're released from DMH, wouldn't they just be released back to the custody of DOC and to stand trial and not into the community?
Not necessarily, no. He's not competent to stand trial. So he is in DMH's custody now for treatment. The court, I mean, there would have to be notice to the prosecutors. The prosecutors could seek to have another competency evaluation done, but it's not necessarily true that he would just go back to DOC.
Right, but if he was there for treatment so that he could be competent to stand trial, presumably that process would begin once he is competent and released from DMH.
If he regains competency, that's true. It's not necessarily the case that he would be competent once he's stepped down to a less secure facility. He could be just as dangerous. And it's not necessarily true that he would go back to DOC because once he's held in an incarcerated system, the goal is the point is to assume that he's then competent to stand trial, and he may or may not be competent to stand trial.
Thank you.
It's nice to see you. It's nice to see you too. I was just thinking when we met and worked together, it was on that